Hey there watching, my name is Aisha Ochoa, and once again, like every other day, I'm here to speak to you about the different ways to conduct your business in the most professional and organized manner. Now, still on this series on contracts and commercial transactions, I will be introducing a few contracts that you will encounter in your journey towards entrepreneurial greatness. Now, we all know that there are two types of contracts. We have the general contracts and commercial transactions and the industry-specific contracts. But for the purpose of this series, we are focusing on the general contracts. There are so many contracts that, regardless of the industry you're in, you may encounter in your day-to-day activities. Now, these contracts could be another party bringing them to you for you to review and come on board, or it could be you as a matter of necessity drafting them or needing them in the course of your business transactions. So I want to define them, explain their uses, when to use them and when not to use them, right? Explain their importance and their legal implications so you know what you're getting yourself into. So stay tuned, don't go anywhere, and make sure you follow through attentively. Now, some of the contracts you may come across in the course of your business transactions include employment contracts, termination contracts, compensation contracts, non-disclosure agreements, non-compete agreements, service level agreements, partnership agreements, lease agreements, purchase or sales agreements, consulting agreements, license agreements, distribution agreements, supply agreements, indemnity agreements, subcontractor agreements, joint venture agreements, intellectual property assignment agreements, intellectual property protection agreements, marketing agreements, freelance agreements, franchise agreements, sponsorship agreements, maintenance agreements, research and development agreements, and tax planning agreements. Now, we are going to start with the first three contracts we'll be dealing with today, which are employment contracts, termination contracts, and compensation contracts. An employment contract is a legal agreement between an employer and an employee that states the working conditions. It states the terms of the employment, it states the obligations, it states the job description, the working hours, compensation, bonuses if applicable, off days, leave time frame, every single information the employer needs the employee to know. And it's also constructed in accordance with the provisions of the labor law and in writing so that it can be referred to by either the employer or the employee in the case of a dispute. Now, every contract has its own uses, right? Just like every other contract, an employment contract has its uses and benefits. Now, let's start with the uses. An employment contract is used to set the terms of the employment. It's good to write everything plain so that we don't go with word of mouth, right? For that reason, we'll rather draft an employment contract. An employment contract will state all the terms of the employment. It's just the employer communicating the work expectations to the employee, but in writing. It states the work hours, the check-in time, check-out time. It states the off days, benefits, bonuses, if we have health insurance in the company, or whatever thing the employer requires the employee to know. So it states all the terms of the contract, the do's and don'ts, and everything both parties must adhere to in the contract. It also serves as a form of protection for both parties because word of mouth may be changed at any point. When there are hard feelings between either party, they may represent the statements or conversations had at the earlier stages. So when everything is in writing, no party can come and say, oh, this is not what you said, or this was how you said it. It has been written plainly, it is in writing. Both parties have affixed their signatures or their seals, so no party can come and say this is not what you meant because everything has been written plainly, right? So it serves as a form of protection for both parties in case of disputes and to avoid misunderstandings. It is also used to set the work policies of the organization and make it understandable for the employee so that tomorrow the employee doesn't say, oh, this is not what you said to me, or I did not know that your organization works in this manner, or I did not know these are the expectations of your organizations from me. So it sets out the code of conduct, sets out the intellectual property clauses, intellectual property expectations, and assignment policies. It sets out the non-competes policies, and even non-disclosure policies of the organization. All of these clauses are outlined in an employment contract. An employment contract is also used to state the acceptable mode for termination of that employment. If you check an employment contract, you usually see a clause that is titled termination, right? This clause determines the various modes by which that employment agreement can come to an end. So this is one of the uses of it. It is used to set out the ways the employer or the employee can terminate the employment agreement. Now, in the case of a dispute, an employment contract also provides for dispute resolution mechanisms, right? Where there is an issue between an employer and an employee, these are the acceptable ways to resolve the issue before going to litigation or going to the media or going out to broadcast. These are the steps you must take first. Then when you do not get any remedy after taking all these steps, then you can now explore other options. So an employment contract always states all of these. So these are some of the uses. There are so many uses of an employment contract, but these are some key uses of an employment contract. Now, onto the importance of an employment contract, because it's one thing for you to understand what it is used for. Now, it's another thing for you to understand why it is important for you to use it. As an employer, it is important for you to draft an employment contract when employing a new staff into your organization, because it shows that you are organized. It shows the highest level of professionalism when conducting and onboarding new staff, when conducting interviews and onboarding because it shows the highest level of professionalism when onboarding new staffs into your organization. You should give them an employment contract. That will also make them sit up, because they know there is something that can be held, against them in the course of misbehavior. Right? There's something that can be referred to, because before an employer would have the mind to draft an employment contract, that employee will know that this person is out for business, this person means business, this person is not joking with this role. So it will give them some form of decency and urgency to sit up and do the work properly. It also provides clarity from both ends to know what their expectations are, as regards the employment. Apart from that, it also serves as an evidence in the case of a dispute. Nobody knows what an employment relationship may result to. There may just be an issue along the line, and then everybody has to wind up in court or arbitration. An employment contract serves as a form of evidence, when it results to that kind of scenario. So it's important for you to have an employment contract. It's important for you to draft it. It's important for it to be part of your onboarding requirements when bringing in new staff to your organization. Now, away from the importance, let's talk about the legal implications of an employment contract. Now, just like every other contract, an employment contract is legally binding on the parties to it immediately they affix their signature or their seal to it. It becomes a legally binding contract once all of the key elements are present, and they execute by way of affixing their company seal or their signature to it. So it's binding on them, right? They have to perform all the provisions provided in the agreement, because for them to affix their signature or their seal, it means they agree to the terms. So once they affix it, once they execute, it means it is binding on them and it is enforceable in court against a defaulting party. So that is one of the legal implications of an employment contract. Another legal implication is that, once an employment contract has been properly executed, the mode for termination must be obeyed. Now, the labor law states different time frames within which notice should be given for the termination of an employment, right? The time frame for an employment under 1 year is different from the time frame for an employment of 10 years. So it's important to execute an employment contract so that the date of that employment can be referred to in the course of termination. So once that contract has been properly executed, the mode for termination will be upheld to, and it can also be referred to the Labor Act, because the Labor Act has already provided laws that even supersede whatever the internal structure states, because it's a federal law, right? So, it's important and it has legal implications. Once it's executed, these legal implications can either be beneficial to the employer or the employee, or even both parties, depending on the circumstances. So even as an employee, it's important for you to request for an employment contract when getting into a new job because you need it. The legal implications may be to your benefit in the case of your employer defaulting the terms of your employment. Now, there are certain clauses in an employment contract in themselves that have strict legal implications. The first is an intellectual property clause. Now, the intellectual property clause of an employment contract usually states who owns intellectual property of every job done or every idea brought forth or everything that concerns intellectual property that happens in the course of the employment. The employment contract usually states who owns the intellectual property. It could either state the intellectual property is owned by the employer, or still give the intellectual property rights to the employee, or state the ratio to which both parties will participate, but it will state it. And when it states it, it is enforceable and binding the minute the contract is executed. Therefore, an employee that comes up with an idea, right, a unique idea in the course of his employment would not have the right to that intellectual property if the employment contract already states that the property would be vested on the employer. So this is an important part of an employment contract that should be looked out for. Once it has been executed, it is binding. Whether or not that idea is so brilliant that the employee wants to take credit for it, as long as the employment contract states that the property will be owned by the employer, then every intellectual property, every unique idea, every work or literary work, whatever it is that comes up during the course of the employment on that job, it will be vested on the employer. Another important clause is the non-compete clause, right? Once an employment contract has been executed and it has a non-compete clause, it is binding on the employee even when the employee leaves the company. So non-compete clauses usually state a time frame within which is binding. It could be 5 years. It will state that for the period of 5 years preceding the termination of the employment, the employee cannot carry on any business or employment that involves the line of business of the employer. So once an employee signs that kind of contract and decides to leave the company, the employee cannot depending on the clause, cannot either get a job in a similar organization or start up a business that is similar to what the employer does. Right? Now, most people set this clause because they are trying to curtail and they're trying to, checkmate the activities of employees. Employees may come on board, gain so much access, get so much information about the company, even go on trainings, learn everything learnable about the company, and get close to the clients, gather the database of the clients, and then decide to resign after 6 months of gathering all the information. So most companies usually set out this non-compete clause so that employees don't come with the mindset of just sucking the company dry and sucking their ideas, learning their trade secrets, getting close to their customers, and then going to start their own business and become strong competitors because they know everything about the business. So once an employee signs this kind of contract that has a strict non-compete clause, he or she is prohibited from engaging in that business for the time frame and within the jurisdiction that has been set out in that agreement. Another important clause is the confidentiality clause. Now, where there's a confidentiality clause in an employment agreement, it means that every information gathered or learned during the course of that employment cannot be shared with another party except with the express authorization of the employers. Now, there's usually a time frame within which it cannot be shared, or some exceptions to the non-sharing rule. Now, where the employee goes ahead to share this information without the express authorization of the employers, there will be legal implications for that breach, because that will be regarded as a breach of the employment agreement. So it's important for you to understand every clause in the employment agreement as an employee before you sign. If it's a business line you intend to venture into on your own and you're just trying to get an employment in that organization so you learn the ropes, you should carefully look at the non-compete clause or the confidentiality clause, even the intellectual property clause, so you do not sign something that serves as a chain and prevents you from even venturing into your desired line of business for another 5 to 10 years. It could be more because different companies set different time frames. Generally, an employment contract is important. For an employer, you must always give every staff you onboard an employment contract because it would help you organize the affairs and serve as a checkmating mechanism for that employee. As an employee, you must understand every employment contract given to you and try to renegotiate on favorable terms so you do not end up signing something that you become bitter about in the nearest future. On to the next, we will be talking about a termination contract. A termination contract can be regarded as the opposite of an employment contract. An employment contract is a contract given to an employee at the point of onboarding, right? A termination contract is a contract given to an employee at the point of letting go. So it's usually a mutual agreement between both parties. By both parties, I mean an employer and an employee, where they come together and outline an amicable way to terminate the employment. Now, in a termination contract, it usually states the reason for the termination, right? The amicable mode of determination, any compensation owed and to whom it is owed, right? And if there are disputes, the amicable way of resolving the dispute. It's a friendly way to end an employment agreement between an employer and an employee. So it's usually used to indicate compensations owed or to revisit clauses that were initially stated in the employment contract, right? So for instance, there were specific number of years for the non-disclosure or the non-compete or even the intellectual property rights ownership. These can be revisited in the termination contract, and they could say, okay, we said non-compete, right? Because we're trying to go on a friendly basis and because we're trying to waive off this and that, you can go into this line of business. So all these clauses can be revisited in a termination contract. It's also used to set out continuous benefits if possible, like health insurance or whatever assets the employer still wants to grant to the employee. All of these will be stated in a termination contract. So it can be regarded as a friendly way to end an employment relationship, so that there are no hard feelings and so that there are no parts of the relationship that are held or that are left unattended to. Now, on to the legal implications. It's literally the same thing, right? It is binding on both parties. Once it has been executed, the terms of that termination contract, even if the terms are different from what was stated in the employment contract, once this new contract has been established, the termination contract, it overrides whatever terms were stated in the employment contract because this is now a new agreement. So it's legally binding on both parties and is enforceable and actionable in court at the point of a breach. So if possible, before signing a termination contract as an employee, make sure you give it to a lawyer to review, so you don't find yourself waiving off rights that you do not need to waive off, and so that you get every compensation that is due you and everything, encompass everything that was owed to you. Make sure you calculate all your bonuses owed, and just a second eye to look through the documents and make sure you're not cheating yourself by signing that termination contract. So make sure it is as fair as your employers have stated it is, because once you sign it, it will be your word against theirs because you signed it anyways. It has become binding on you. So make sure you always get the advice of a lawyer. Make sure you always get a legal advice before you sign any document, not just a termination agreement. The third agreement we'll be discussing is a compensation agreement. A compensation agreement, just like the name states, a compensation agreement is an agreement that is entered into by two parties, usually an employer and an employee, to state the mode of compensation payment. It can also be called a remuneration agreement, right? To state the mode of payment, allocation of bonuses, how to earn commissions, everything about payments as regards that employment. This could be a separate agreement that states it. Now, it's usually drafted in order to ensure transparency, right, and to retain top talents, because there are some people who are so valuable in their field and they just want to get all the benefits that are due to them that they feel they deserve in the course of an employment. So some employers will go ahead to draft a compensation agreement, even separate from the employment agreement, so they understand that, listen, we take this thing really seriously, and for that reason we're drafting this agreement to make you understand that not only are you going to be working for us, you are also going to grow and benefit in the course of the job. So it states their hourly or monthly wages or salary. It states the whatever benefits, health insurance, car insurance, housing insurance, payment of fees for kids, different things, everything that serves as a form of benefit. That compensation agreement will state all of that. It is also used to ensure retention of top talents, right? And appeal to a staff's loyalty. Once a staff knows that compensation is on standby and there are so many benefits, in fact, for that reason, there's even an agreement that states it and clearly outlines all the benefits, the staff will increase performance. So it's used to increase staff performance, to ensure staff retention of top talents, and also to motivate members of staff to be more loyal and dedicated to the job. Now, onto the legal implications of a compensation agreement. The first one has been established in the other two agreements we stated. Once it is executed, it is legally binding. That's standard. Now, the essence of drafting a compensation agreement is to outline the terms. The terms are the modes of payment and benefits due. Once this contract has been executed, it is binding on the employer. Regardless of the employer's change in plan or whatever goes on, as long as it has been executed, it is binding on the employer. Every benefit the employer has stated will be due to the employee upon the fulfillment of that job must be paid to the employee. So it is enforceable against the employer in the case of a default. That is a standard legal implication. In fact, that is the first legal implication. Once you sign it, everything you have promised in that compensation agreement must be paid to the employee. Otherwise, it will be considered a breach of contract and it will be actionable against you as an employer. Now, there are different types of contracts you will come across in your day-to-day activities. The reason why you will encounter these contracts is because you are tidying up your ends and making sure there are no loose ends or loopholes in every commercial transaction you will encounter. Now, I'm talking this way because I assume that as a visionary leader, you will, properly document and draft intelligent contracts for every transaction that involves another party, because in commercial transactions you must draft contracts.